Jay Sekulow is the Chief Counsel for the American Center for Law and Justice. Ilya Shapiro is Senior Fellow in Constitutional Studies and Editor-in-Chief of the Cato Supreme Court Review. And Mark Levine, a former congressional attorney and host of RadioInsideScoop.com. Gentlemen, welcome to the Glen Beck program. Mark, to you
Thanks,
first.
Judge.
Is there any area of human behavior that Elena Kagan would acknowledge is not subject to congressional regulation?
Well, sure. Any element of human behavior, that's pretty wide. You'll have to be more specific.
Well, would she let the Congress write any law or control any behavior, tax any event, or would she say, you know what, your conversation with your physician is private, the Congress can't regulate that, the words that you speak are protected by the First Amendment, Congress can't regulate that?
I'll give you an example. Congress tried to pass a law banning flag burning, right? And that would be a violation of free speech, which is granted to every individual American citizen, and that would be overturned. And that was overturned by Justice Scalia as well. So
Okay.
I mean, I'm a strict constructionist. I believe in following the literal language of the Constitution, which is why, by the way, I'm so despondent about this Second Amendment jurisprudence, which isn't based in the text of the Constitution.
All right, we'll get to the Second Amendment in just a minute. Jay Sekulow, is Elena Kagan a progressive? Does she believe that the Constitution can be stretched and pulled in any direction the Congress wants so as to let it regulate any behavior it wants, as Justice Thomas once feared a Tupperware party if they want to regulate it?
I'm afraid so. Look, you just look at her actions. You know, she has no judicial record, but you look at that situation with the military recruiting on Harvard's campus. You had a federal law that was in play that said you allow equal access to the military recruiters. It's very straightforward. It's very simple. She says no. She files a brief again. And Judge, the most liberal members of the Supreme Court of the United States, all 9 justices, in fact, and the most liberal, disagreed with the position that Elena Kagan took in that case. I think, look, it's a progressive, no doubt about it. That's the reality of a consequence when you have an election. That's what you get.
Ilya, is the reality of the confirmation hearings such that she will be confirmed almost no matter what she says, because she's nominated by a president who's a member of the same party that has 59 senators, and they only need 51 votes to confirm her?
Almost no matter what she says is right, I think, unfortunately. But look, this is more than about Elena Kagan. This is about the frustration and the reaction among the American people in general to all of these government takeovers of so many different sectors of our society, from banking to the auto industry to student loans to, of course, health care. And the American people will see, if the Republicans do their job correctly, what the differences are in real constitutional interpretation. And as Jay said, being a progressive and not really having any checks on government power, despite what the Constitution says.
Mark, probably long before she ever imagined that she would be in the hot seat, she commented in a very famous comment, now famous, that these confirmation hearings are bland as pablum, and members of Congress have a right to know exactly what the nominee thinks. Question: can the Republicans ask her things like, are you a progressive? Will you permit the nationalization of banks or industries that the Congress decides that it wants to own?
Well, the general reason why these things are pablum is because it's an understood rule, and it has been for decades by both Democrats and Republicans, that you don't ask a judge their view on a specific case. You ask them how they rule, what things they take into context, whether they, for example, believe in the text of the Constitution, or they think that it changes over time, what do they think about judicial activism.
All right,
but you don't want to make them like politics.
Does she believe that the Constitution is a living document that means something different today than it did 20 years ago, or it will 20 years from now? Or is she a textualist like Justice Scalia, who says it's meant the same thing for the past 230 years, subject to the amendments?
Well, I wouldn't agree with your definition of textualism. She's not an originalist. In other words, she doesn't believe that whatever the founders believed in, things like slavery and no women's rights, has to hold true today. But she is a textualist like myself. I firmly believe in the text of the Constitution. When the Constitution says equal protection under the laws, for example, the 14th Amendment, the people who wrote it didn't believe in equal protection for blacks. But when you read the document by its plain language today, by its text, it gives all persons equal protection under the laws, and we believe blacks are people today.
Thank you, Mark. Jay, do you think that Solicitor General Kagan believes that the Constitution is a living document and can be stretched and pulled to accommodate anything that the Congress or the court wants it to accommodate?
Judge, I'm afraid so. And I'm going to take it a step further and disagree with Mark's statements here. Look.
Go ahead.
There is a significant, they're changing the definition of what we mean by textualists or originalists. That's what Mark just did. The fact of the matter is they believe in a living document. Now, the Constitution is living to the extent that there's an amendment process that allows for amendments, like prohibiting slavery.
Right.
That's in the Constitution through the amendment process. Here's the issue. Is she going to abide by that, or is it going to be whatever she decides that date, not based on history, not based on the text? I'm afraid that's where it's going. That's reality. You've got a case that's coming up right now. The Supreme Court granted review today. She's confirmed she's going to be hearing the case. It involves Arizona, an immigration issue, and federal authority.
Right.
It's a big case. It's going to have huge impact, and I'm afraid this is where you're going to see exactly where Elena Kagan is.
Ilya, in the grand scheme of things, is there likely to be any ideological shift as a result of her joining the court? Are we not just substituting one 50-year-old progressive for one now retired 90-year-old progressive?
Well, don't undervalue what that means, because if she serves another 40 years, that's significant. But more broadly, I mean, she does have the intellectual chops to be the liberal Scalia, if you will. So this is a significant move, much more than replacing Justice Souter with Sonia Sotomayor was. But the types of questions that really need to be asked aren't about specific future cases. Is the individual health care mandate unconstitutional? She's not going to answer that. But how about give me 3 examples of activities that the Congress can't do using its Commerce Clause power. Give me 3 examples of government regulations that you think that are currently in place that might not be in place in the future.
Mark?
There are ways of approaching things.
Mark Levine, give us 3 examples where Elena Kagan thinks the Congress can't exercise its Commerce Clause power, because it can find almost anything to be commerce, even somebody growing a plant in their backyard that they never sell, that they consume on their own, no cash exchange hands. It doesn't go from one state to the next. The court can find that to be interstate commerce and let the Congress regulate it. What do you say?
As you know, that's the United States Supreme Court holding, and it has been for at least 50 years, ever since the Ollie's Barbecue case defended civil rights. So that is the current holding of the United States Supreme Court, and I suspect she'll support stare decisis on this. But I do want to make a distinction, if I could, very briefly, between liberal textualism and conservative textualism.
Well, let's not get too into the weeds here. Go ahead.
Well, but it's important because look at the definition of person. Liberals believe that blacks are people and therefore are protected under the 14th Amendment, all right, even though the founders didn't believe that. Conservatives believe that corporations are people. Now, liberals say corporations aren't human beings. They're not people. So corporations, you find that conservatives view judicial activism.
This is not a liberal conservative argument.
He changes the context of the words. This is the typical liberal attempt to redefine what terms really mean.
I guess this is what we'll be listening to.
Right is right, wrong is wrong, and that's it.
Guys, this is what we'll be listening to all week. And as you know, Mark, the court has held that the corporations are persons for the past 100 years. It has nothing to do with liberals or conservatives. But gentlemen,
but if
thanks,
you're a textualist,
we gotta go. Thanks for joining us on this.
Thanks, Judge.
Up next, a look at the violence and the outcome of the G20. Stay with us.